And as personal injury lawyers, we often get asked this question: can I sue my landlord? Of course, here we're talking about personal injuries. We're not talking about other kind of landlord-tenant disputes. But generally, this is the answer to this question, of course, as a lawyer, is it depends. But I want to do a little bit better than that. Obviously, if you've been injured at an apartment complex or some kind of rental property, please give us a call that we can more fully evaluate your case. There's just too many variables, too many nuances in this area of the law to really accurately answer this question with more than it depends. But I'm going to do my best to break down at least two. These are two main statutes behind me. In the red text here, Official Code of Georgia, OCGA. These are the two statutes that govern landlords' duties to tenants in the state of Georgia. So the first is the statute requires landlords to keep the premises in repair. So if the tenant notifies the landlord of the need for a repair and the landlord fails to do that within a reasonable amount of time, and then the tenant is hurt as a result of whatever the condition is that needed repair, then the landlord can be liable for those injuries. This is a little different from the second statute, which is what I would just call a Georgia premises liability statute. And this just says that when somebody, such as a tenant, is an invitee on the premises, that the landlord or the property owner more generally owes a duty of reasonable care to keep the premises reasonably safe. In the landlord-tenant context, that extends really only to the common areas of the property. That's just because you can imagine once the landlord hands over the keys to that apartment to the tenant, they're not going to go in and inspect the apartment anymore for unsafe conditions. Again, it's a different matter if the tenant notifies, hey, this needs to be fixed, but they're not going to go through and walk through the apartment, obviously, like they would owe that duty in the common areas. The landlord does still owe that duty for common areas, parking lots, walkways, etc. So that's really the big difference between these two is again the duty to inspect versus relying on the tenants to notify the landlord when there is a problem. But generally the answer to this question, when can I sue my landlord, is when the landlord knew or should have known that there was a dangerous condition on the property, failed to correct that condition within a reasonable amount of time, and then the tenant is hurt as a result, or the tenant's guest for that matter. And generally, this is shown in a few ways. We call this actual or constructive knowledge in the law. So actual just means that the landlord actually knew about this. Like, for example, the tenant told the landlord about a problem, the landlord didn't fix the problem. And constructive is just essentially you should have known, the landlord should have known about this issue. Sometimes this could be a building code violation where an expert says this condition violates this specific building code. Other times it's often shown by just the length of time that a dangerous condition was allowed to exist. Again, this goes back to the duty to inspect. So if the reasonable landlord would have inspected, walked the property every so often, and that inspection, a reasonable inspection, would have revealed this problem, this dangerous condition, then that's going to be a situation where the landlord reasonably should have known, a reasonable landlord would have known about this problem, and again, the tenant gets hurt as a result of the landlord's failure to correct that problem on time. One last bit about landlord-tenant cases. It's a little different from like premises or slip and fall cases in the commercial business context, like a retail store, for example. And the reason is that it's just a different policy, right? Georgia has a policy of preventing unsafe residential housing. So, for example, the front stairs to your apartment are rotten and unsafe, and you, the tenant, have notified your landlord about this problem, and then you get hurt as a result. If that were a retail store, courts might say, well, you shouldn't have gone up the stairs. You saw that they were dangerous, and you even said something about it. You knew that it was obviously a problem. In that situation, in the residential landlord-tenant context, that would be less of a concern, because courts recognize that that's just not fair as a matter of public policy to the tenant, because how is the tenant expected to get in and out of his or her apartment? Courts are not going to hold you what they call a virtual prisoner in your place of residence simply because the landlord refuses to do what it is required to do under the law. So again, if this is something that you have questions about, if this applies to your situation or somebody you know, please give us a call, and as always, thank you for watching.